Good afternoon, everyone, and thank you for joining today's webinar discussion, Voting Laws in the 21st Century. My name is Kamanzi Khalisa, and I'm Director of CSG's new Overseas Voting Initiative. Late last year, CSG entered into a 4-year partnership with the U.S. Department of Defense's Federal Voting Assistance Program to improve the U.S. military and overseas voting process. Our initiative's aim is to build state policymakers' awareness of voting challenges currently facing U.S. voters residing overseas. This initiative will manage 2 working groups consisting of select state and local election officials. The Elections Policy Group is currently examining the Presidential Commission on Election Administration's military and overseas voting recommendations, and the Technology Group is exploring technology issues affecting state election management systems across the nation. Previously, in another life, I worked for the Georgia Secretary of State in Atlanta, directing the federal Help America Vote Act program and improving the election administration process there in Georgia. Saying that, I'm pleased to be joined today by 2 of the nation's foremost election law experts, constitutional law professor at OSU's Moritz College of Law, Dan Tokaji, and professor of law and political science at the University of California, Irvine, Rick Hasson. Gentlemen, thank you for joining today's discussion. And so let's jump right in, shall we? Question 1. So, gentlemen, it seems wherever I go, people are constantly asking me about the flood of state voting laws being challenged in federal and state courts. I was asked quite recently, by a colleague at the Congressional Black Caucus's legislative conference here in Washington, D.C., basically, Kamanzi, what's driving all of this? So I really would like for you to provide, both of you, some historical context and background on what is driving this movement. Is it the U.S. Supreme Court's previous rulings in Crawford versus Marion, the Indiana photo ID case, or the Shelby County versus Holder, the voting rights Supreme Court case? Is it the push simply by many state legislatures to enact new voting laws? If you guys could just take turns and just tell the story behind what we are all watching unfold at this point in American history.
I'm happy to start on that. This is Professor Tokaji. There's a stated reason for these laws, and then there's what, at least in my view, is really going on. So the stated reasons for this wave of new restrictions on voting that we've seen really since 2011 is, first of all, preventing fraud. An argument is made especially with regard to voter ID laws, which have been probably the most controversial issue, that they're needed to prevent people from cheating, from going to the polls pretending to be someone they are not. There are also sometimes arguments about the costs and administrative convenience issues arising from such things as same-day registration and early voting. So those are the stated reasons, at least some of the stated reasons for some of the new restrictions on voting. The real reason, in my view, for many, if not most of these laws is that legislative bodies are trying to serve their own interests by making it more difficult for people of the other major party to vote. If you look behind some of the rationales that are given, especially the anti-fraud rationale, you will often see much less there than might meet the eye. There's also evidence that some of these restrictions on voting bear particularly heavily have an adverse impact on poor people and racial minorities, as well as young people, college students. Most of these restrictions have been enacted, the vast majority, in fact, by Republican-dominated state legislative bodies for whom these groups are generally voters that overall support the other major party, the Democratic Party. So it seems to me there is a partisan motivation for many, if not most, of these laws.
Yeah, this is Rick Hasson. I would add to what Dan Tokaji said by going back to the 2000 Florida disputed election. After that election, what we saw was a flood of new legislation as well as new litigation, both of which seem to stem from the realization that in very close elections, the rules of the game can make a big difference. And so we've seen a big uptick in the amount of new voting rules that are put in place. And the pattern, as we heard, was that Republican legislatures have seemed to favor laws that make it harder to register and to vote, and Democratic-dominated legislatures have passed laws making it easier to register and to vote, and both of these track with the perceived interest of the parties, which is an expanded electorate helps Democrats. On top of the legislation, many of these rules have been challenged in both state and federal court as violations of various federal statutes and the Constitution. The amount of election litigation has more than doubled in the period after 2000 compared to the period before 2000. And that pattern has been pretty steady throughout the last period, the last few years. The reason that we're seeing a kind of flood of cases, including 4 cases that made it to the Supreme Court over the last month, is that many of these cases were in progress, but there were questions that arose as to whether or not new election rules that were adopted by Republican legislatures could be put in place for this election. So as these cases were moving along, that emergency issue came up and eventually worked its way to the Supreme Court. And so it's not a coincidence that these are coming right before the election, as decisions have to be made as to what the rules are going to be during this election.
So by my latest count, voting laws in 8 states have been recently challenged in federal and state courts. I would like both of you to go state by state and have you both explain the current status of each state's voting law case as you guys see it, just providing your legal analysis and the merits of the various cases and decisions. And I think it'd probably be best to break these cases down. If we could start with the voting ID cases, and that would involve the states of Wisconsin, Texas, and Arkansas. Could you guys just kind of go state by state discussing those 3 separate issues, those 3 separate cases?
It maybe makes sense to divide them up.
Okay.
I'll just start by talking about the status of Wisconsin's law. Wisconsin passed a voter ID law a few years ago. The law was challenged in both state and federal court. Initially, the state Supreme Court, the state trial courts, held that the law violated the state constitution, put the ID law on hold. Recently, the state Supreme Court reversed that, and in the course of reversing that, required the states to make certain changes to the voter ID law to make it somewhat easier for people to get free identification if they can't afford the documents they need to get an ID. Meanwhile, in federal court, a federal district court in a case called Frank versus Walker decided that the law violated both the U.S. Constitution's Equal Protection Clause as well as Section 2 of the Voting Rights Act. That case went up on appeal to the United States Court of Appeals for the 7th Circuit. The 7th Circuit then was asked preliminarily by the state of Wisconsin to allow the law to go into effect for this election. The court issued an order allowing that. That order was reversed by the Supreme Court, primarily, we think, although we don't have the court's reasons, on grounds that the law was, that the changing the law so close to the election risked electoral chaos. There was initially supposed to be an 8-month rollout of this voter ID law, but it was going to have to be done in less than 8 weeks. So the Supreme Court put the Wisconsin voter ID law on hold, but in the meantime, that same 7th Circuit panel of 3 judges reached the final merits and said that the law violated neither the Constitution nor the Voting Rights Act. One of the judges of the 7th Circuit, Judge Posner, who was not on the panel, objected, called for a vote. There was a 5-to-5 split on whether or not to take the case to be heard by the whole 7th Circuit, and the case looks like it's heading back to the Supreme Court sometime probably within the next few months.
And, okay. Professor Tsukaji, do you want to add anything there with Wisconsin?
I think that's enough. I mean, we got a lot of cases.
Sure. Okay.
Provided a great description.
And what about Texas, gentlemen?
So why don't I take that one? Texas has a voter identification law that is widely considered to be one of the, if not the most restrictive in the country, requiring photo identification in order to vote. A district judge in Texas, Judge Nova Gonzalez Ramos, issued an opinion finding on multiple grounds that Texas's voter ID law violates federal law. She found it was a violation of equal protection, that it was an unconstitutional poll tax. She also found that it was racially discriminatory in violation of the Voting Rights Act. So the district court judge issued an injunction, a court order that would have prevented the law from taking effect. That order, however, was stayed by the appellate court, the Fifth Circuit Court of Appeals, and there were different grounds stated by two different judges on that three-judge panel, but what they have in common is a concern that this order stopping Texas's ID law so close to Election Day would actually cause more disruption than it avoided, resulting in confusion for poll workers as well as voters about what ID they're required to show. So the bottom, and the Supreme Court declined to intervene in that case. So bottom line is that Texas's voter ID requirement is in effect for this election.
Okay. And I guess that will bring us to Arkansas. Arkansas was a different type of voter ID challenge in that it is in state court. So far, I believe it's only been in state court. And we recently had a ruling from the state Supreme Court which found that the ID law violated the state constitution by impinging on the qualifications of voters. And so that's not a ruling that really could be appealed to the U.S. Supreme Court, since it involves a state constitutional issue. And so I expect the next thing that will happen in Arkansas is that supporters of the voter ID law will try to pass a state constitutional amendment, which would then moot this holding of the state Supreme Court. So for now, no tough voter ID law in Arkansas, but it could come back if it's possible to get a state constitutional amendment on that question.
What about the early voting case concerning Ohio's Golden Week? I'm not sure if our audience is aware that the 7 days of early voting, affectionately called Golden Week in Ohio, also included 7 days of same-day registration.
Right.
What's your take on that case, the Ohio case?
So why don't I start, since I'm in Ohio. Actually, both the Ohio case and the North Carolina case involve restrictions on same-day registration as well as early voting. In Ohio, we have, for several election cycles now, had a period beginning 35 days before the election and ending 30 days before the election when people can both register and vote, a form of same-day registration that is, as you noted, referred to as Golden Week. The Ohio legislature earlier this year, a legislature that is dominated by Republicans, voted to eliminate this period for same-day registration and early voting and make other cuts in early voting as well. A portion of this wound up being reversed in a different court decision, the Obama for America case, which was first filed in 2012 to challenge restrictions on early voting. The federal district court in Ohio found that the remainder of these restrictions on same-day registration and early voting were likely in violation of both equal protection as well as the Voting Rights Act, finding that these restrictions would have an adverse impact on voting, especially voting by poor people, by racial minorities, and by homeless people. The Sixth Circuit Court of Appeals in this case affirmed, but the Supreme Court wound up staying the injunction that the court had issued way back at the beginning of September, and wound up issuing that stay just the day before same-day registration and early voting were set to begin here in Ohio, which in my view is causing a lot more disruption than it resolved, given that the Supreme Court itself has warned against last-minute court orders, exactly what it did in this case.
Yeah, I would just add to that I would say that the Ohio case raised somewhat less significant issues in terms of effects on voter turnout than either of the Texas or Wisconsin cases. And that's because even after this ruling of the of the U.S. Supreme Court, there will still be 28 days of early voting in Ohio, many more opportunities for early voting than exists in a number of other states, including some states like New York, which offer no early voting at all. And so there's a big conceptual question, which the Supreme Court eventually is going to reach in one of these cases, as to what it means for there to be a violation of Section 2 of the Voting Rights Act. Do you look, or how much do you look at the fact that a state may have had more generous voting rules and then cuts back on them, versus a baseline of what do other states do and what is kind of the minimum requirement in order to be able to meaningfully cast a ballot? And so there are a lot of questions, and the Supreme Court's emergency rulings in these 4 states, Ohio, North Carolina, Texas, and Wisconsin, doesn't really tell us what the court's going to do when it ultimately has to reach the merits of these issues, but it might reach different decisions in cases like Ohio compared to cases like Wisconsin.
Yeah, and Professor Hassan makes a good point. I do think it's fair to characterize the burdens imposed by Ohio's law as less onerous than, say, those imposed in North Carolina, Wisconsin, and Texas. The real prize in the Ohio case was the elimination of same-day registration opportunities during that 5-day period. Now, while the burdens are less from the elimination of same-day registration and the restrictions on early voting, the state's arguments in Ohio were especially unpersuasive, in my opinion. You know, in the voter ID cases, the main argument is fraud, and there's at least some logic to the anti-fraud argument for voter ID, even though the evidence of how often fraud actually occurs is, well, that it occurs quite seldom. With Ohio's law, under which same-day registration ended 30 days before the election, there was no plausible anti-fraud argument, and yet that was the main argument that the state was making as to why it needed to get rid of this very limited period for same-day registration. So while the burden on voters was less in the Ohio case, the state's arguments were especially pretextual looking, or at least so the lower courts thought.
And Professor Tokaji, you made a few references to North Carolina. What is your take on the North Carolina case? I understand that that was a very comprehensive state voting law passed in 2013. Yeah. What's your analysis there?
Yeah, North Carolina, the broadest set of restrictions on voting. They include restrictions of a law that restricted multiple things, including early voting, imposing a voter identification requirement, eliminating cast in the wrong precinct. The lower court, the lowest court, I should say, the United States District Court, rejected the call by voters in the NAACP in North Carolina to enjoin, that is, to stop this omnibus voting law from taking effect. The Fourth Circuit partly disagreed and issued an order that would have required some of these changes to be stopped, at least temporarily. However, the United States Supreme Court wound up staying that order of the Fourth Circuit, which basically means that all of North Carolina's new restrictions on voting are in effect for this election.
Okay. Professor Hassan, I understand that there are citizenship cases involving voting in Arizona and Kansas, and I guess they're being challenged in federal courts. What's your take there?
That raises a somewhat different question, a really important question. But those cases, unlike the four we've been discussing, has really flown under the radar. But it involves the question of state versus federal power in relation to setting the rules for voting in congressional elections. So just to back up, Congress passed a law in 1993 called the National Voter Registration Act, sometimes referred to as Motor Voter, which gives the federal government, first it gave the Federal Election Commission, then it gave a group called the United States Election Assistance Commission, the ability to create basically a postcard that people anywhere in the country can use to register to vote in congressional federal elections. This postcard could be used anywhere regardless of what the state requires on its own voter registration forms, and so it's been a very useful tool for groups running voter registration drives across the country. Now, Kansas and Arizona don't want to accept registrations that are coming in on this federal postcard form unless those registrations are accompanied by documentary proof of citizenship. That is, proof of a birth certificate that you were born in the United States, or naturalization certificate, or other evidence that you are currently a U.S. citizen. So there were a bunch of different ways in which Kansas and Arizona tried to challenge that. The current case is pending before the United States Court of Appeals for the 10th Circuit, and the question in that case is whether or not Congress, through passing this law, has the power to impose this requirement on the states that they accept this form. And the constitutional question is whether or not Congress imposing this power is an exercise of Congress's power to set the manner of congressional elections, which is given to Congress in the Constitution. But the states are given the power to set the qualifications for voters. And so the question of whether you're requiring proof, documentary proof of citizenship counts as a qualification for voting is the question before the court. It's a very arcane legal question, but it has very important practical implications. If Kansas and Arizona win, it means that a bunch of voting restrictions might be able to be imposed even if Congress objected to them on grounds that states have the power to set qualifications. If Congress wins, it means that Congress really has broad powers to prevent the use of various means, such as voter ID laws, for example, if Congress wanted to, that for use in federal elections if Congress wants to do so. One side note on this, in the meantime, as this litigation is going forward, Kansas and Arizona have created dual voter registration systems where you might be registered using the postcard under the federal form, but you can't vote in state elections. And those dual systems have also been challenged in court. So it's a very complicated situation, but a very important set of cases that ultimately I think will also be heading to the Supreme Court.
And finally, the Iowa State voter registration, I guess some policy changes to that system implemented by the sitting Iowa Secretary of State, Matt Schultz. What is your take on that situation? I know that there's a challenge there in the state court in Iowa.
Yeah, I mean, the issue is somewhat similar to Arizona and Kansas, only the issue in Iowa is simply one of state law rather than implicating the relationship that Professor Hassan just described between federal and state law. In Iowa, as in Arizona and Kansas, the Secretary of State is concerned about non-citizens being on the voting rolls, but the nature of the legal claim is different in Iowa. It's a claim that is based on state law grounds only. A lower state court in Iowa has said that the Iowa Secretary of State didn't have the power under state law to remove ineligible voters in the way that the Iowa Secretary of State sought to do, and on that basis has stopped those changes, that removal of voters from taking effect, at least for the time being.
And I would like to ask both of you about your personal predictions on how most of these state voting cases, and I guess the larger issue of voting rights, will be settled beyond next month's elections. Obviously, most of the recent U.S. Supreme Court emergency rulings haven't really decided the actual legality of the various state laws. So what's your take there, gentlemen? What's your prediction? How will it all shake out, if you will? And I won't hold you to it if it doesn't go your way.
Well, I would separate out the 4 cases we've discussed first, North Carolina, Ohio, Wisconsin, and Texas, versus the other cases, which raise either state law questions or questions about the Elections Clause, which are different. But focusing on those 4 cases, the 4 that went to the Supreme Court on a temporary basis, the key issue before, or the 2 key issues before the Supreme Court are the scope of the Equal Protection Clause of the 14th Amendment of the United States Constitution. How far does it protect voting rights, especially when it comes to passing restrictive voting laws? And also Section 2 of the Voting Rights Act, which has a very well understood meaning in the context of redistricting cases, but we're only getting the beginning of cases, and they're dividing on what Section 2 means in the context of what Professor Tokaji has called the vote denial cases, cases where it's not about diluting votes, but about making it harder to register or to vote. So far in the courts, judges who are more liberal, judges who have been appointed by Democratic appointees, have tended to read both the equal protection and voting rights standards quite broadly to protect voters, while more conservative and Republican-appointed judges have tended to read it more narrowly. If that same pattern holds up in the Supreme Court, where we have 5 more conservative Republican-appointed judges and 4 more liberal Democratic-appointed judges, we could well see a 5-to-4 split on both the constitutional and voting rights questions when they make it to the Supreme Court. But there's no guarantee of that. We did have Judge Posner of the 7th Circuit, who initially voted to uphold Indiana's voter ID law, but a few years later changed his mind. So nothing's certain, but if I had to predict, I would think that these arguments are going to have a tough time in the Supreme Court.
Professor Tokaji?
Yeah, I tend to share Professor Hassan's assessment here, and let me be a little more, blunt and perhaps inelegant in my view of
please, yes.
I'm very worried about what the United States Supreme Court will do to the fundamental right to vote, which the Court has long emphasized is critical because it is preservative of all other rights. None of our interests as citizens can be protected unless we're able to vote and unless our votes have equal weight in comparison with those of our fellow citizens. And in my view, the lower courts have generally done a very good job, especially the federal courts, of protecting the right to vote in recent years, which isn't to say I agree with every single decision that's been issued, but I think that they've done a good job, and sometimes it's been Republican-appointed judges, especially in my state, who have issued opinions joining in limiting or striking down some of the restrictions on voting. So Professor Hassan's certainly right. A lot of the decisions have been along party lines, but not all of them. And I think the lower courts have done a really good job. The United States Supreme Court, at least the majority of that court, is, in my opinion, no friend to the right to vote. So I'm very worried about the Supreme Court rolling back protections for voting rights under both the Constitution and the Voting Rights Act. This court showed in last year's Shelby County decision that it's no friend of the right to vote, and it is especially concerned about race-conscious remedies for voting, like the Voting Rights Act. So I'm really worried about what the Supreme Court is going to do once it gets a hold of one of these cases and decides them on the merits, as it is likely to do at some point in the not-too-distant future.
Well, thank you both very much. And this is a legal policy conversation with Professors Tokaji and Hassan. Thank you for joining us today, and see you next time.
Thank you.
Thank you.